Masechet Ketubot Daf Kof. We're talking about the assessment of land and how to make sure to get a fair price when someone is selling on behalf of someone else. So Mishnah says, Shum hadayanim shepichatu shetut or hosifu shetut michran batel. If a court is selling land, let's say on behalf of orphans to raise money to pay a creditor or the widow, and so they go and assess the value of the land, but they make a mistake and they assess it to be a sixth or more less than it's actually worth, or a sixth or more an increase more than it's worth, then michran batel, that sale is null and void. If they sell it for too little, the orphans can come and say, hey, you've sold it for too little. And even though they're the bet din, the orphans have a claim, you cheated us, and therefore it's void. Or if they overpriced it, then the buyer can come and say, hey, you overpriced it, I paid too much. And if it's just a little bit more or a little bit less, that's fine. This is related to the law of ona'ah. In general, if I sell you a camera and I overcharge you by more than a sixth, then you have a right to come and claim and say that I overcharged ona'ah, and therefore the sale is void, and you can get your money back. Or the opposite, if you paid more than a sixth less than it's worth, then I can come and say I want to void the sale. So this is true for a bet din as well, assessing land. That's the opinion of Tanakama. That's the Chachamim. However, Rabban Shimon ben Gamliel Omer, Michran Kayam, Imken, Makor bet din Yafeh. Rashbag says even if the court charges too much or too little, they assess for too much for too little, nevertheless the sale is valid, because if you say it's void, then where do you see the power of bet din, right? Then it would be the same as any messenger who makes a mistake, or the widow herself, if she makes a mistake, then it's void, because they're cheating the orphans or cheating the buyer. But the whole point of going through bet din is we're going to go through an official channel who can be trusted, and therefore that is the authority of the bet din, that even if they make a wrong assessment, that assessment sticks. That's why we're going through the bet din in the first place. So that's Rashbag. Now everyone agrees, however, aval. This is back to Tanakama. Im asu get bikol benehen, afilu machru shaveh maneh b'matayim or shaveh matayim b'maneh michran kayam. If the bet din goes ahead and makes a public announcement, it's called a document or letter of inspection. You get it, like the Megillat is still called an Igeret, something that you read out loud, a proclamation of inspection, saying everybody come and inspect this land and see how much you think it's worth. In other words, a public auction. Then no matter what the amount they sell it for, it is valid, even if it's something that's worth 100 and they sell it for 200. Now usually when you say the sale price actually is what it's worth, right? The market determines what the price is. What they must mean here is that it's a piece of land that normally, according to the regular formula of the square footage and the location and all that, normally would go for 100 based on normal standards. But if they find someone that's willing to pay 200 and it was a public auction, then that sale is valid. Or the other way around, if it was worth 200 and they only got 100 for it, but they did this public auction, then everyone would agree that the sale is valid, even Tanakama. But Rashbag would say it's always valid, even if they don't make a public auction. Okay, that's the Mishnah. Now, question. Shaliach keman. So if there is an agent, let's assume it's an agent of the court. So what's the status of an agent of the court? It's not the whole court coming and making the assessment, but a single agent who's working on behalf of the court. So what status does that person have? Rava Amar Rav Nachman Shaliach Kedayanin. Rava says it's the same as the Dayan. Since the judges have authority to set a price, so too and they can be off. The point is that the judges, even according to Tanakama, the judges have a right to be off by an amount up to a sixth, and it's still valid. So the messenger of the Dayanim have the same law. Whereas Rav Shmuel bar Bista Amar Rav Nachman, both of them are saying in the name of Rav Nachman, so two different opinions within Rav Nachman. So Rav Shmuel, however, says Ka'almana, it would be like a widow. If a widow is selling land of the orphans, in order to raise money for herself, then if she has to get the number exactly right. If she's off, even by less than a sixth, then the sale is void. So Rav Shmuel says that a messenger of the Bet Din does not have the status of a Bet Din, but rather is like a single person, like the same as an almanah, and does not have that 1/6 leeway. What would be their reasoning? Rava amar Rav Nachman shaliach kedayanin, ma dayanin lav ledidhu, av shaliach nami lav ledideh, la pukeh almana de ledida. So the reasoning of Rava in the name of Rav Nachman, who says that the single messenger is the same as a full court, is because, just like regarding the judges, they're not selling it on their own behalf, therefore they're not going to be biased. So too, the messenger is not selling it on his own behalf. He doesn't gain anything by selling it for more, he doesn't lose anything by selling it for less, and therefore he's going to be fair, and therefore has the same law that he's, even if it's more or less, up to 1/6, according to Tanakama, it's still valid, and this would exclude the widow because she's selling it for herself, so she has an interest in selling it for more, because that way she can get more. Okay, Rav Shemuel bar Bisna amar Rav Nachman ke almana ma almana yichida af shalich yachid la pokeh bet din de rabim ninhu. So the other opinion within Rav Nachman, Rav Shemuel says a single messenger is like the widow, just like a widow does it singly, and a single person is never as good as having a group, because single person determines something but doesn't have a counterweight to discuss it with. When you have three people and then each one takes a different view and they discuss it, and then they can come to the truth more clearly. So it's not about them having a vested interest, but rather being a single person. The messenger is like the almanah, and so that's why it would be void if it was not the correct price, and that excludes a bet din. Bet din is a group of three people at least, and that's why they can make a better determination. So the bottom line halacha is that a messenger is like the widow, and if they make an error, even a little error, then it's void. We're going to challenge this. But how is this halacha different from the following Mishnah Terumot that we already learned yesterday? If a landowner asks an agent to go and separate terumah for him, and he doesn't know how much he doesn't specify how much he wants, so the agent should figure out, what does this landowner usually like to give? Does he like to give generously, or is he stingy? If he doesn't know, then he should just give the average, the middle amount, which is 1 in 50. But if the agent added 10 more or 10 less to the denominator and gave 1 out of 40 or 1 out of 60, that's still valid. So here we see if an agent is off by a little, it's still valid. But up here you said that an agent is like an almanah, who cannot be off, not even by a little. They have to get it just right. So how do you account for this difference? Hatam kevan deika de torem bayin hara veika de torem bayin yafa amar lelachi amadetich avalacha ta'utahu amar le la'ibaelach lemit'eh. In the case of teruma over there, where some people give in a stingy way, some people give in a generous way. So the agent said, I figured that you're going to be a guy who's generous and going to want to give a little more or less, and so it's all within the range of possibility, and so it's all valid. Whereas in the case of selling land on behalf of someone, you want the right price, and if it gets the wrong price, even if it's off by just a couple of percentage points, nevertheless, that's called an error, and the sender can say, "I did not want. You should not have made an error. You should have been more careful." So, in the case of terumah, it's not about being careful or not. It's all within the realm of the range of what people normally do. So there's more than one, correct possibility. But getting the price right, you have to get the price has to be right, and so that's why it has to be exact if it's a messenger. Amar Rav Huna bar Chanina Amar Rav Nachman halacha kedivrei chachamim. Now back to the Mishnah, Chachamim say that the messenger has to get it, the bet din rather, it has to be within 1/6 of an error to be valid. More than that, then it's invalid. That's Chachamim. As opposed to Rashbag, who said, Makoch betin yafeh, that the betin has the authority, and therefore, whatever they decide is valid, even if they're off by a lot. Okay, question. Let le Rav Nachman bar Nachman levelet le Rav Nachman makoch betin yafeh. Rav Nachman, who you claim said the halakha is like Chachamim, but does he not apply the principle of where do we see the power of the court? He does in the following case. V'hamar Rav Nachman amar Shemuel. יתומים שבאו לחלוק בנכסי אביהן, בית דין מעמידין להן אפוטרופוס ובידין להן חלק יפה. When orphans have to come and divide their father's estate, but they're young, so the Bet Din will appoint a steward for them, and the steward will choose for each child a proper portion. Okay, so they have to trust that the steward is going to divide it up fairly. However, higdilu yecholim limchot. When the orphans grow up, they can say, you know what, he didn't do a good job. They could protest and say, I'm not happy with my portion. It's not fair. Now, Rav Nachman didei amar higdilu en yecholim limchot. Rav Nachman, regarding that very case, that was Rav Nachman, the name of Shemuel, but Rav Nachman himself disagreed with Shemuel and said, even when they grow up, they cannot protest, because otherwise, where is the power of the court? The whole point is that the court is going to appoint this person, and then whatever he says goes. If anyone who doesn't like it then protests and overturns, so it's like the Bet Din doesn't do anything. So here we see that Rav Nachman does apply this principle of makoach, and that yet up here he said the halakha is like Chachamim, who disagree with Rashbag, and Chachamim do not say makoach. So which one is it? The case of the Mishnah, where Rav Nachman said the law is like Chachamim, is where the Bet Din made a mistake, and they made it 20% more or less. And so there, because they made a mistake, it is null and void. And so we don't apply makoach in that case. Whereas here, regarding the apotropos, who's dividing the estate for the orphans, they did not make a mistake. It's not a clear error. It's just that one of them is unhappy, even though it's not an actual mistake. It's a fair division, but nevertheless someone is unhappy. So what does that mean? If the steward did not make a mistake, then on what basis is one of the orphans protesting when they grow up? And the answer is beruchot. They don't like the location, the direction. Right? If one of the orphans has some other land up in the north, and so he wants the northernmost, and the steward didn't realize that and gave him something in the south. So even though it's all equal size and fair amount, nevertheless he can protest regarding the placement, and so that's what was going on here, and it's on that Rav Nachman says no, you can't protest because it's not a mistake. Whatever the steward did is done, even if you don't really like the direction that of the land that he gave you, but nevertheless it is valid. Whereas if they make a total mistake and just misassess a land, then we don't say apply makoach, and it's overturned. Ki ata Rav Dimi amar maaseh v'asar bi ke-divrei Chachamim. And now a story about following Chachamim. Rav Dimi came from Eretz Yisrael, and he said, Rabbi Yehuda Nasi, a case came before him where the Bet Din assessed something, and it ended up being more than a sixth off. And he followed Chachamim and invalidated the sale. Amar lefanav Perata beno shel Rabbi Elazar ben Perata ben beno shel Rabbi Perata. We have a lot of people named Perata, and each one named after their grandfather. So we see that they must have been Sephardic, that they named after their grandfathers. Shel Rabbi Perata Gadol, named after the great one from the earliest generation. And he said, Im ken makor bet din yafeh, and he applied the principle of, well, in what sense would be where would we see the authority of the Bet Din if you're just going to overturn it? And once he said that, once Perata said that to Rabbi, Rabbi says, oh, you're right, I changed my mind, I reversed my ruling, and I'm going to say that the Bet Din's ruling, the Bet Din's assessment is valid, the sale is valid. And so you see that he was going to follow Chachamim, But in the end, he followed Rashbag. Okay, that's one version of the story in the name of Rav Dimi. Rav Dimi matni hachi. However, Rav Safra matni hachi. Rav Safra also had the same story, but with a slightly different version. In this version, Rabbi sought to. He says, I think I'm going to decide on this case like Chachamim, that because the Bet Din misassessed the land, sale is invalid. But he didn't give a ruling yet. Not a final ruling. Amar lefanav perata, beno shel Rabbi Elazar ben perata, ben beno shel Rabbi perata hagadol. So same sage. Im ken makor bet din yafeh. So perata was there and said, Rabbi, if you say that, then where will you see the authority of the court? You can't just overturn what a court says. And then lo said Rabbi tamase. And so Rabbi says, you're right. I'm not going to take action on this case. Meaning he only thought about ruling like Chachamim, but in the end he didn't. So that's the two versions of it. What's the difference between two versions? Lema b'hakami palged. Morris sabar ta'abid bar mishnah hozer. Maybe the first version of Rav Dimi is based on the opinion that someone who makes a mistake regarding a law that's transmitted in a mishnah, that could mean the mishnah as we have it, or more likely it's in the oral law. Chozer, even if it's not a doraita, but still, it's merely an oral law. Nevertheless, if a judge makes a mistake and didn't realize, forgot something about the oral law, then he has to overturn the judgment. And so that's what Adimi said, and that's why in his version it would be overturned his judgment. Whereas Rav Safra thinks that one does not overturn the judgment. That's why in his opinion, if it be had already issued the ruling, he would not have overturned it. That's why in his version it has to be that he was thinking about following Chachamim and then he didn't. So is that the difference between these two stories? No, not necessarily. Maybe in fact everyone agrees that if you make a mistake regarding an oral tradition, you do have to overturn. And the machlok is just that's happened. What was the actual case? Rav Dimi thinks that he actually gave a ruling, and Rav Safra remembers it differently, that he didn't actually give a ruling. So the controversy here is not about a basic principle, but just what happened to be the case in that story. Amar Rav Yosef, al malta dezabina achrayut ayatme, ubed din dezabin achrayut ayatme. We also saw this statement earlier, Rav Yosef, that says a widow who sells property, even though she's the one that's making the sale, making the transaction, she's only acting as an agent for the orphans, and it's the orphans that therefore have to give the guarantee. They have to provide the title insurance should someone come and repossess the land, some creditor. Then it will be the orphans that will have to be responsible for paying back the buyer. And if a Bet Din sells land on behalf of orphans, then also the responsibility is upon the orphans. You're not going to go to the Bet Din and say, they repossessed that land that you arranged the sale of, therefore the judges are going to have to go and take money out of their pocket. No, they were doing this on behalf of the orphans. And so therefore, that lien, whoever a lien holder comes and repossesses it, the orphans have to pay back the buyer. Okay, we say, Peshita, isn't this obvious? The widow, the Bet Din, they're only acting as messengers for the orphans. So why would we think otherwise? And the answer is almana la istarich aleh ki istarich le bedina. So you're right. If it was regarding the widow, it's obvious, and you wouldn't even have to say this law is true about the widow, that it would be the orphans that have the guarantee. But we are saying, Rav Yosef said this whole statement because of the Bet Din, where it's not so obvious. Mahu detema, kol dezaben mi bedina, da'ata lemapek lekalahu dezaben kamash malan. I might have thought that anyone who buys from a Bet Din, when the Bet Din is involved and they announce it, so when the Bet Din, when anything the Bet Din does is public record, and so therefore this is going to have a widespread knowledge that this land is for sale. sale, and therefore the buyer might assume, since this has a public notice on it, anyone who has a lien on the land or claim on the land of any sort will then come to the Bet Din and say, hold on, how could you can't sell that land? That's my land, right? I had owned it before. I bought it before. I have a lien on it. I need to claim it. And so since nobody came to the Bet Din to claim the land, therefore it's free and clear, and I'm guaranteed by the Bet Din themselves, in the process that they used, that I, the buyer, am sure to keep it, and no one will take it. So I might have thought that would be the case, that it doesn't even need a guarantee because the Bet Din guaranteed it. The orphans don't have to. Kamash malan. So therefore, we teach that that's not true. It could be that afterwards, maybe a guy was away or he didn't act immediately. They don't lose their claim to the land if they do have a valid claim or a lien. And should they come and repossess it, the orphans will have to be responsible for making up the difference. Now back to the Mishnah, Rabban Shimon ben Gamliel, Omer, he's the one that said that if the Bet Din overprices or underprices is still a valid sale, because that's the whole point of the authority of the Bet Din. The question is, Vad Kama, how much? I mean, even if they sell it for 100 times the price or a tenth of the price, it's got to be some limit. Amarav Huna, Badi Huda, Amarav Sheshat, Ad Palga. Yes, in fact, there is a limit, and that would be half. Half or double, that would be the most that is valid. Any more than that, invalid, or less than that, invalid. Tanyana mehachi amar Rabban Shimon ben Gamliel, betin shemachru shaveh 200 b'maneh or shaveh maneh b'200 michran kayam. And we have a braita that confirms this interpretation, that according to Rashbag, a Bet Din that sells something that really is worth 200, but they sell it for only half, or if it's worth 100 and they sell it for double, then that is valid. But if it's more extreme than that, then their sale is invalid. They have authority, but not to such an extent. Amar Mishme de Rav Yosef, Bet Din shemachru belo hachraza nasu kemi sheta'u bidbar mishnah vechozrin. Now, Amemad has a halachic ruling that says a court must make a public announcement that they're going to sell it. That's a public auction. If they do not make this announcement, then they are making a mistake in a matter of a mishnah. Or rather, na'asu. It's as if they're making a mistake in a matter of oral law, and therefore their decision does not stand. It's reversed. Their sale is reversed. They have to make this announcement. Now we ask, na'asu v'dai ta'u. What do you mean it's as if they are making an error in a matter of Mishnah? It's actually an error in the matter of Mishnah, because here's the Mishnah. Tiznan shum hadayetomim sheloshim yom v'shum hekdesh shishim yom u'machrizin ba'boker u'ba'erev. We see it's a matter of established oral law that whenever the Bet Din is selling the land of orphans, they have to announce it for 30 days. And when they are trying to assess how much an item is that was made, that was consecrated, and now they have to know how much it's worth, they announce that 60 days, and they announce it in the morning and in the evening. So we see that these definitely have to be announced, and so if they don't make an announcement, it's an actual error of Mishnah, not like an error of Mishnah. Why did it say like? Yeah, the answer is no, if I only had this Mishnah, it doesn't say that this is talking about a Bet Din. I would say maybe this is talking about a messenger of the Bet Din, if he has to announce. But maybe the Bet Din themselves, they have many people and they're experts in it. Maybe they don't have to announce. So that's what Amemad is saying, that a Bet Din also must announce, and if they don't, it's equivalent to a shaliach not announcing. Either way, it's invalid. Challenge to Amemad. Itiber Rav Asher Amemad shum hadayanin shepachatu shetut o hotiru shetut michran batel. Quoting our Mishnah that says when judges make an assessment, if they do a sixth less or a sixth more, then it's invalid. Now, what kind of case are we talking about? Ha-shaveh b'shaveh michran kayam. Only if it's more or less than this much, then it's invalid. If it's exactly a sixth, right, or less than a sixth, then it would be valid. Now, so why is it valid, even though it's not right on target? My love de la achruz, are we talking about a case that they did not announce? and even though they did not make an announcement, still, if they're off by less than a sixth, it's a valid sale. So this challenges a memad who says if they did not announce, it's an invalid sale. So we answered, lo b'da'chruz. No. Why are you assuming that they didn't make an announcement? Maybe they did make an announcement. That's the reason why, when it's only a little bit off, then it is a valid sale, because they did make an announcement. Now we say, no, that can't be. The sefa of the Mishnah is surely when they made the announcement. So therefore, there has to be a contrast between the beginning of the Mishnah and the end of the Mishnah. And so here's the end of the Mishnah. The katana sefa im asu, we get it bikodet, if they made this letter of announcing, and everybody should come inspect. Then everyone would agree that if they sold 100 for 200 or 200 for 100, it is valid. So surely that is describing an actual announcement. If the sefa is about announcement, that means that Resha was when they did not announce. And even so, in the Resha, if he's only off by a little bit, it is valid. So you see, it can be a valid sale even if the Bet Din does not announce it. So you're right, it has to be that the Resha is talking about a case where they did not make an announcement. Yet we can reconcile this with Amemar as follows: Kan b'dvarim shemachrizin alehen, kan b'dvarim she'en machrizin alehen. When Amemar said that you have to make an announcement, that's talking about items that the practice is that we announce regarding them. But the Mishnah in the Resha that says even if you didn't announce, it's still, and you're off by a little, it's still okay. Those are talking about, that was assuming items that we do not usually make announcements about. For example, the following items you don't have to announce about them: servants, movable items, and contracts. Why? Because if you're going to make an announcement, hey, Mr. So-and-so is going to be sold as a slave. All right, so he's going to say, I'm being sold, I better get out of here, he's going to run away. And so therefore, we don't announce it, because that way they won't try to run away. And if you announce, oh, this Mr. So-and-so, he has this item, it's worth... he's being sold. It's a very expensive item, right? It's going to go for $1,000. Another guy comes and says, I'll pay $1,200. Now everybody knows this guy has an expensive item, or he has a contract, so a loan contract that he wants to sell. It's worth $1 million. Everybody's going to know about that. They're going to go and then possibly steal it from someone. Someone may come to steal in his house. So therefore, these items is always best not to announce. And so that's what the Mishnah is talking about. If they do not, even if they don't announce and they're only off by little, that is valid. But other items, you have to announce. Or another way to resolve the contradiction between Amemar and our Mishnah, kan b'sha'a shemachrizin, kan b'sha'a she'en machrizin. We're not talking about different items, but rather different times. That Amemar is talking about a time when we make an announcement, and the Mishnah is a time when we don't make an announcement. What do you mean, a time? When there's a time crunch, meaning. So the rabbis in the Hardah say that if you have an estate that's taking care of orphans, and you need to pay the head tax for the orphans, or we have to provide food for them, or we have to take care of a burial. So these are things you can't wait 30 days to make an announcement and then figure it out. They have to eat in between, right? The head tax has to be done now. The burial has to be done immediately. And therefore, in these cases, we do sell the orphan's property even without an announcement. So this is what the Mishnah was talking about, and why it's still valid, even though they did not make an announcement. But in other cases, Amemad is right, and you have to make an announcement. Or a third answer to resolve the contradiction between Amemad and Mishnah. It's not about the items, it's not about the time, but rather about the place. There are some places where they announce, and some places that they do not make announcements. In the Nehar Da'ah, they never made this public proclamation of a sale of everyone come inspect, because it's something going to be for sale. There's two reasons why they did not make such announcements in the Nehar Da'ah. So one possibility is because they're experts, right? They know exactly. They look at a thing and they know how to assess how much it is, so they don't need to make public announcements. That's what Rav Yosef thought, but that's what Rav Yosef thought Rav Nachman meant. But then Amar Rav Yosef about min yomeh. Lediti mifarshali mined Rav Nachman. Later on, Rav Yosef said, actually, Rav Nachman explained it to me fully. The statement that he said before, right? I didn't understand it at first, but then he explained to me exactly the reason that in the Har Da'ah they do not make public announcements because mishum dekaru lehu b'nei achle nichse te'achrazta. Because what happened is that anyone who would buy something from this kind of public sale, public auction, people would make fun of them. It says, "Oh, look at this guy. He goes buys things from public auctions. What do they sell in public auctions? Land and items that were seized from orphans, right? So they're calling it. The people will call such a buyer an ambulance chaser, someone who takes advantage of people that are down and out, orphans that have to sell their land. And so this guy goes and buys that. So people were embarrassed to go and buy land that was sold in public auctions, and then it was missing the whole point because then they weren't getting the best price. And so that's why in the Har Da'ah they stopped doing the public auctions. It was counterproductive. Amar Rav Yehuda Amar Shmuel metaltelin sheyitumim shaminotan mochrinotan le'altar. Now, before we're talking about land, but movable items that are left in an estate, one should assess them and sell them immediately so that they don't go down in value, especially if it's something that's perishable, like food. Rav Chisda Amar Abimi Mochrinotan Lashvakim. Rav Chisda said you sell it on the market day. You go to the marketplace. There's lots of people buying and selling, and that's the best way to do it. These two opinions are not actually arguing on each other. If the market day is close by, then sell it on the market day in the market. But if it's far off and you don't want to wait so long, then you should assess it and sell it immediately. In other words, do whatever is best for the orphans. Rav Kana hava bidei shichra de Rav Meshashia bar Chilka yatma. So Rav Kana had some beer that belonged to Rav Meshashia bar Chilkai, who was an orphan. I assume that he wasn't a rabbi yet when he was a child, but eventually he was. So when he was an orphan, he had this beer, and Rav Kana had to take care of it as the agent. Shehaya ad rigla. And even he did not follow this rule and sell it right away, but waited until the holiday. Amad afal gav de nafal be isasta maitezuza harifas. Even though it's going to be not quite as good, it'll have a little sourness to it because I'm waiting so long. Nevertheless, it's going to bring in a better price on the holiday. So he calculated, in that case, better to wait and get a higher price than to sell it right away. So you see that there are exceptions to these rules, and the bottom line is do whatever you think is best, whatever will serve the orphans the best, get them the best price with the least risk. Another story is about Ravina, that he was in possession of wine, meaning he's the steward to take care of the wine, of Ravina the younger when he was an orphan, who happened also to be his nephew, Ravina's nephew. So this uncle is taking care of his nephew orphan wine. Ravina himself also had wine that he had to sell. His own wine he was taking to Sichra to sell. It was a good place. People like to buy it there. So Ravina asked Rav Asher, can I take my nephew's wine along with my wine, right? Or do I have to follow the rule before and sell it right away, sell it locally? Because anytime you transport something, you're adding risk that might be stolen, might break on the way. But can I do the same with their wine as I am with my own wine? And Rabbi Asher said, for sure you should. Their wine is no better than yours, and so if you're treating yours this way and you think this is the best deal for you, the lowest risk and highest gain, then surely that is a good option for the orphan's wine as well. And so once again, a couple of general rules and then a couple of stories. The point being that if one is taking care of wine of orphans, one should make sure to do it in the best way possible. And we'll leave the new Mishnah for the next daf. Baruch Adonai Leolam. Amen ve'amen.